Well, good afternoon and happy Thursday to everybody. Happy Thursday, this March 31, so tomorrow is April Fool's Day. Bill O'Leary coming to you live, and it's part of my Thirsty Thursday series, where every Thursday at about this time I go live and I talk about a different topic that may interest me in what I do. So I'm an attorney. I do elder law, estate planning, probate, and trust administration. So, as I like to start off these talks saying, if you're thirsting for knowledge, you have come to the right place. So, today's topic, the title I've given it is what happens to the inheritance of a minor child. So, if a minor child receives an inheritance, what happens? So the question is, can minor children be beneficiaries, first of all? Well, of course they can. Sure they can. But here's the catch. They can't legally own property or assets until they become of age. So what happens when you, or let's say someone else, let's say maybe a grandparent, leaves an inheritance to a beneficiary who is still a minor? What happens? Well, it depends on the kind of inheritance that it is and the law of the state where the loved one passed away, as well as the law of the state where a minor child resides. If they're different, then we have to figure that out. So when property or assets are left to a minor child, like through, let's say, a joint ownership of a property or an account, or maybe given to the child because the child's a beneficiary on what's called a pay on death or a transfer on death type financial account, the minor won't have the legal authority to take control of that money because of their age. So, and the same holds true, by the way, for an inheritance that's received under a last will and testament, or from what's called an intestate estate. Intestate, that simply means where someone passes away without a will. And also the same applies where the minor cannot receive it if they are due to receive something through a living trust, if, let's say, that trust was not set up correctly. Now, if the value of the property or the assets that's left to the minor child is not significant, then oftentimes what the state law will say is that an interested adult, let's say that the natural parent, may be able to ask that minor's inheritance be placed into a special kind of account. Could either be what's called a Uniform Transfer to Minors Act account, an UTMA account. Occasionally it might be transferred into what's called a Uniform Gift to Minors Act, an UGMA account, although the UTMA account, Uniform Transfer to Minors, is done more commonly. And so, and where these accounts can be helpful is that they can hold the funds for the child until the child turns the age of majority, 18 in most states. Some states bump it up to 21. Also, some states allow for an interested person to ask that the property be placed in another kind of account, a holding account called a 529 account for the benefit of the minor. And this is done for education expenses, and it's basically it's a tax favored type of savings plan to help pay for future college costs or private tuition costs in high school, that sort of thing. Now, in some states, parents can personally assume the management of very small amounts. In Florida, that amounts $15,000. So let's say a grandparent wants to leave a $15,000 gift to a minor grandchild. The parent would not have to use this specialized UTMA account or UGMA account or 529 account, but can basically take control of the money completely. Now, if the asset value that's left to a minor is more than what can be placed in an UTMA type of account, or let's say the laws of the state where the minor lived, they don't authorize these types of accounts to receive an inherited assets, then a court supervised what's called conservatorship must be established for the benefit of the minor. The court appointed what's called personal representative, or the executive of the estate. What they'll do is they'll file a petition with the court asking that a conservator be appointed on behalf of the minor to manage the inheritance when the probate estate is being opened. That's the time that would be done. And if there's, by the way, no probate estate, let's say where the minor is named as a beneficiary on a life insurance policy or retirement account, then any interested person can go ahead and file that to petition for a conservatorship. And by the way, the interested adult could be an aunt or uncle, although it doesn't have to be a relative, but oftentimes it is. And the important thing is to make sure it's somebody that is truly trusted. And then once that petition is filed, a judge then decides who to appoint as the minor's conservator after maybe hearing evidence testimony from all interested persons, if there are several that want the job. And sometimes the judge may ask to hear from the minor child themselves if, let's say, they're, maybe old enough to sort of comprehend what's going on. Maybe they're 12 or 13 or into their teenage years. The judge can certainly hear from them. And that exact age sort of varies depending on the state. In most cases, the child's parent ultimately is chosen to be the conservator, unless both parents, let's say, are deceased, or maybe it's otherwise determined it would be inappropriate to name the parent. Maybe they're not capable of performing that important responsibility. And the appointed conservator, by the way, is going to take over management and control of the minor's inheritance until the minor becomes an adult. Parents leaving inheritances to their minor children have to do it in the right way, okay? Otherwise, it creates a lot of difficulty in having to name a conservator. So the bottom line is this: even if a child is at the legal age to be a beneficiary, they may not have the maturity to manage a large amount of money, and that's why many parents in their estate planning establish a trust that the child cannot touch until they're even older than age 18, let's say 25 or 30. Very commonly done, so they become a little bit more mature and are less likely to waste away an inheritance. So, let's say you've got a child with an addiction issue, or a gambling issue, or whatever it might. Maybe they're just irresponsible with money. It makes it more likely they're going to squander their inheritance, squander it away, recklessly. Those are also great candidates for that kind of planning, which involves putting in place a trust. So, if you'd like to know more about what happens to the inheritance of a minor child and perhaps how we can help, we would love to chat with you, to make it very easy, to make that easy sort of baby step, that first step. We encourage you to go ahead and book a free 15-minute discovery phone call with us. Just go to our website, legacyplanninglawgroup.com, legacyplanninglawgroup.com. Find the big blue button that says book your free call. It takes you to our booking calendar. Just pick the day and time that works for you, and it's a chance for you to tell us what's on your mind so we can tell you if we can help you. Again, that 15-minute call is complimentary, and it's a very easy first step to have, okay? So if you've enjoyed this video, I'd ask that you like it, and better yet than liking it, if you could share it with your friends, just trying to get the word out. So I hope you've enjoyed this talk about what happens to the inheritance of a minor child. Again, as I said, I'm going to be giving another talk next Thursday at about the same time, different topic. So if you are thirsty for knowledge, we will quench your thirst, as I like to close with. So Bill O'Leary, signing off. On behalf of everybody here at my firm, Legacy Planning Law Group, we call ourselves Team Legacy. Go make it a great day and a better world.